Begin the questions by recognizing myself for 5 minutes. Mr. Hinnen, with respect to the so-called lone wolf authority, since terrorism is obviously a crime, why do we need this provision? Why not use ordinary Article 3 warrants? What additional powers does this provision give beyond the normal Article 3 warrant, and why are those powers necessary?
Thank you, Mr. Chairman. The distinction, I think, between Article 3 powers and FISA powers are the factors recognized by Congress when enacting FISA in the first place. The needs of the government in conducting intelligence investigations. Whereas when using Article 3 authorities, you are investigating the violation of one of the criminal laws. In an intelligence investigation or a counterterrorism investigation, the government is often not intending to investigate a violation of the criminal law and often doesn't have prosecution as its end goal.
Regardless, can you get a lone wolf warrant in a circumstance where you couldn't get an Article 3 warrant?
I think it's the conditions under which you can get the authority that are important. The additional secrecy that it provides that protects an ongoing intelligence investigation.
The additional secrecy, aren't Article 3 warrants under seal?
They may be under seal, but those orders are eventually unsealed, as are the applications that underlie them. And often the predicate facts that support the issuance of such an order are of sufficient sensitivity that the government does not want them.
So if Article 3 warrants had the authority to keep certain things, what you were talking about, secret, then that would be an adequate substitute for that?
I think still the important distinction between the requirement under FISA that the government demonstrate that the individual is an agent of a foreign power and the requirement under Title III that the government demonstrate that...
But in the roving wiretap, they don't have to demonstrate that. I'm sorry, in the lone wolf, they don't have to violate.
Under lone wolf, the government still has to demonstrate that the target is an agent of a foreign power under the definition as an agent.
But so you're telling me it's harder to get because they've got to demonstrate something that they don't have to demonstrate for an Article 3. So my question then is, assuming you took care of the problem of potentially unsealing records eventually because you want to keep certain things secret, what advantage is there to the government in terms of an investigation, aside from having to jump through additional hoops to get the warrant in the first place, which is not an advantage, to using this as opposed to an Article 3 warrant?
Mr. Chairman, I didn't mean to imply that it was more difficult to get a FISA court order, simply that the government had to make a different showing.
Fine, but let's assume, never mind that. Why is it to the government's advantage, other than the question of declassifying information eventually? Let's assume we amended that. What's the advantage of a roving wiretap as opposed to an Article 3 wiretap?
That the showing that the government has to make in order to get a FISA wiretap is more closely tailored to an intelligence investigation, that it focuses on an agent of a foreign power rather than a violation of the criminal laws.
So you could get it under certain circumstances when you couldn't get an Article 3 wiretap?
The government gets it by making a different showing.
But in such a, and the facts are such that there are cases in which you could make the showing necessary for a roving wiretap, but couldn't make the showing in the same case necessary for an Article 3 wiretap warrant?
I believe that there's some overlap, but not complete overlap.
I would ask then that you, after today, because I want to go to 2 other questions in the minute I have left, give us specific information on how it would be advantageous to the government, on why, assuming we plug that secrecy problem, why Article 3 warrants wouldn't suffice. I mean, how does it really differ? The administration has noted in its support for the reauthorization that it's willing to consider proposals to better protect privacy as well as efficacy. Given that position in the context of Section 215 orders, would the administration support returning to a standard that required specific facts showing that the records sought are related to a foreign power rather than the current relevant standard? And if not, why not?
Thank you, Mr. Chairman. It's an interesting question whether the administration would support a return to this particular specific and articulable standard which existed before the Patriot Act as opposed to the relevant standard. This, of course, is something that Congress changed in the original Patriot Act. the administration has not taken an official position on this yet. I would say, sitting here today, that it's not entirely clear to me that there is a substantive difference between the specific and articulable standard and the relevance standard. If there is in fact not, then I would suggest that settled expectations militate in favor
Well,
of...
clearly, if there's no difference, it doesn't matter, but everybody
in
seems
fact,
to have said for the last 10 years that there's a big difference.
If in fact there is a difference, I think the presumption would be against change.
Say again? I'm sorry.
The presumption would be against change, against returning...
Because?
In part because Congress recently made the change to the relevance factor, in part because a practice has developed around the current standard, and in part because Congress has added additional safeguards, including judicial review of orders in 2006, and it's...
Well, again, I would simply say this, and then my time will have expired. Saying that we shouldn't change something because Congress did it is never a good argument, because we're always changing something. I would ask you, again, after the committee, after today, to supply us, if you think we shouldn't change that, with specific reasons other than, we're already doing it this way, but specific reasons and illustrations of how that would affect intelligence gathering and why it would not be a good idea to change it.
Certainly.
Thank you.
Mr.
My
Chairman.
time has expired. Would you restate briefly, you said that the Section 206 roving wiretaps had broader authority or less safeguards than the criminal roving wiretaps. And what was the one the specific one you cited?
That it doesn't compel the identification of the person or require the government to determine that the person is actually using the communication device.
And therefore can be used pretty widely.
Right.
Mr. Wainstein, why should not the Section 206 contain that protection or that requirement that's in the criminal version of roving wiretaps?
Well, as to the authorization to issue an order based on a description as opposed to the identity of the person, that particular issue, that's a recognition of the reality of what we're dealing with when we're dealing with people, foreign spies and terrorists. These are people we often don't know the name of. These aren't.
Well, and you don't have the same situation in the criminal context?
Well, less frequently. It's less frequently a problem because sometimes we do have people who come in who, let's take it outside the context of foreign terrorism, foreign espionage, which are crimes, and look at drug trafficking. Yeah, sometimes there are people whose names we don't know, but in the foreign intelligence context, people who come in here as spies and operatives of foreign intelligence services go to great lengths to hide their identity. So we often will not know, but we'll know darn sure that they are a representative.
In other words, you know his appearance, but you won't know his name?
Well, we'll know, we'll have watched him, we'll have seen him with physical surveillance, we might have gotten a pen register and seen that he's got contacts with other people who are known operatives. And keep in mind, we can only get the FISA court order if we show sufficient specificity in our description of the person
Okay.
to satisfy the court.
Mr. German, why would you disagree with that?
Well, I don't think there's been a sufficient showing. I mean, I would love for the government to publish how this authority has actually been used, and then we can have a debate based on the facts. But
Thank
right
you. Ms.
now-
Spalding, you alluded to the same thing in your testimony. Could you comment on this little dialogue here?
Yeah, I am sympathetic with the challenges that the government might face in knowing the name of the target of the surveillance. I think then that it is very important that the statute explicitly require that this target be identified with sufficient specificity to eliminate or significantly reduce the risk that the wrong person is going to be targeted. And the risk is enhanced when you come to a roving wiretap, where you're changing facilities and instruments that you're tapping. So to require great specificity in the description of the target, and also showing by the government that there are reasonable grounds to believe that that particular individual is going to be proximate to and using that instrument become very important.
And the great specificity would be the same as or similar to what we have in the criminal code?
It would be similar to, but again, I'm comfortable with having the government not knowing the name of the target if they are able to describe that individual with sufficient specificity.
Thank you. Now, Ms. Spalding, you noted in your written statement that Congress should consider requiring the government to set forth in the initial application the grounds upon which it believes the disclosure of a Section 215 order would be harmful. The disclosure. Why do you believe that this consideration is important? And when you answer the question, talk also about the NSL, similar question.
You ask that question again. I don't have a hearing aid.
I'm sorry. I asked her, why Ms. Spalding had said in her testimony that it is important that we should consider requiring the government to set forth in the initial application the grounds upon which it believes the disclosure of a Section 215 order would be harmful. In other words, why to get the gag order? Why do we need the gag order? I am asking Ms. Spalding, why do you believe that this consideration is important? And when you answer the question, comment in the NSL context as well as the Section 215 context, please.
Thank you, Mr. Chairman. I think it's important for a number of reasons, and it is particularly relevant in the Section 215 and NSL letters when they are delivered to third-party record holders, when it's delivered to a business asking for the records of a third party, of another individual, because they really have very little incentive to challenge the gag order, to challenge the underlying order itself, or to challenge the gag order. It is not in their best interest to have it publicized that they are handing over to the government customer information. And so putting the burden on the recipient of the order to challenge that requirement not to disclose really dramatically reduces the likelihood that it's going to be challenged. And in fact, with regard to challenging underlying orders, the Department of Justice letter acknowledges that no recipient, no business recipient of a 215 request has ever challenged the order, which I think is pretty compelling evidence that they.
So the whole debate that we had last time during the reauthorization of the grounds for challenge might be a little irrelevant?
And the Second Circuit recently ruled in the context of national security letters that in fact putting the burden on the recipient as opposed to on the government raises some real serious constitutional issues.
Thank you. I'll just have one more question, Mr. German. The 2008 IG report on the FBI's use of Section 215 orders noted that the FBI issued national security letters after and the chairman alluded to this, after the FISA court denied requests for Section 215 orders to get the same information. The FISA court said this implicates First Amendment concerns. You can't get the orders, so they just went and issued NSLs to themselves. The court based its denial on First Amendment concerns. In your opinion, as a former FBI agent, do you believe the FBI is using NSLs to evade the requirements of Section 215 orders, especially given the relatively low number of Section 215 orders that are issued, in contrast to the very large number of NSLs? And if so, what should we do about this problem?
I don't know if I can say in the context of my experience as an FBI agent, because I didn't work with the...
In the context of all your experience.
But certainly the facts that were relayed in that Inspector General report reflected that there was court concern about the First Amendment violations that were occurring in this request for documents. So the fact that the FBI continued and ignored the court's advice, I think, does show abuse. And, you know, clearly the report details considerable abuse of national security letters.
But that also would show, would it not, that if the FISA court refused to grant a 215 order because it said the facts implicated First Amendment concerns that should prohibit it, that the NSLs should also not have been issued because of the same First Amendment concerns, but that there was no check on the power of the FBI to make sure of that?
Exactly right, that there was no outside check allowed the abuse to happen.
My last question, Mr. Wainstein, how should we fix that? In other words, how do we ensure that the FBI or the Justice Department, which doesn't have to go to court to get an NSL order, that the proper safeguards are there so that you can't implicate the First Amendment the way the court said you couldn't do in the 215?
Well, I think you have to take a sort of a broader view of it. First, this is not the only administrative subpoena authority out there. There are 300-some administrative subpoena authorities on the criminal side used every day, every minute of every day around this country by federal authorities, and they have different requirements, but essentially the same idea, that they're issued directly by the agency to people who possess third-party records. So this is not an anomaly here. With the NSLs are not an anomaly. They're actually a tried and true part of the toolkit that law enforcement and Intel have used for years. Secondly, keep in mind this is one incident that was highlighted by this IG report that otherwise... There was one other, right, but this is the one that sort of got most attention, that looked at a lot of activity, and they found this one concern. I don't believe that this is symptomatic of a broader problem that the FBI is going out to try to subvert the First Amendment. Keep in mind, these are different investigative authorities. The 215 has a different standard it has to meet. The FISA court found that the information was thin and didn't want to issue the order, and said that it thought that it might, I can't remember the language, but that it might be, the investigation might be based on First Amendment activities. I'm quite confident that the General Counsel's office did not just lightly blow off the FISA court opinion, that they did go back and look at this and decide that under the different standard for NSLs that it was appropriate.